May it please the court, my name is Geddes, initial EL of counsel, and I appear for the accused, Marshal Ike. Your Honour, my client is a 14-year-old Torres Strait Islander boy who has been charged on 84 counts of break and enter and 1 count of stealing. As counsel for the accused, I would like to submit that in relation to these offences, the police have not followed the correct legal procedures as stipulated to them under the Police Powers and Responsibility Act 2000. My submissions highlight the unjust and unreasonable conduct of the police, which will result in a miscarriage of justice should the courts choose not to exercise their judicial discretion to quash the indictment under Section 590 AA of the Criminal Code. Firstly, I would like to submit that my client wishes to change his plea to not guilty. Your Honour, I wish to make submissions regarding the improper questioning of my client on 2 instances. I will now refer you to the facts of the case in the first instance. The relevant police began their questioning of my client in response to a phone call they had received about a break and enter. It is my submission that my client never received a support person during the questioning stages by the police. In fact, my client did not receive a support person until the formal interview process. This indicates a clear violation of his rights and an infringement to the requirements of Section 420 and Section 421 of the Police Powers and Responsibilities Act. My client is a Torres Strait Islander and a relevant person to whom the principles entrenched under Section 420 of the Police Powers and Responsibilities Act applies to. The facts of the case indicate that the police often refer to my client as a young fella. This in turn leads to the inference that the police suspected my client to be of an Indigenous background, as this term is often used to communicate with persons from the Indigenous culture. This makes Section 420 applicable to my client. It is my submission that the police were in strict contravention of Section 420 of the Police Powers and Responsibilities Act by questioning my client without affording him the right to a support person. Your Honour, at no time during the questioning of my client did my client waive his rights to be afforded a support person. Had he maintained his rights to a support person, proper procedural fairness would have been awarded. Your Honour, the second breach lies within Section 421 of the Police Powers and Responsibilities Act. This is relevant to when a police officer wants to question a relevant person and reasonably suspects that person to be a child. My client is 14 years of age and satisfies the legal requirement of a child. The breach of Section 421 of the Police Powers and Responsibilities Act relates to this case insofar as it indicates that my client should not have been questioned by the police until receiving the right to speak to a support person. This right was not given. Your Honour, it is my submission that the breaches of Section 420 and 421 of the Police Powers and Responsibility Act highlight a vulnerable person who has not been awarded his legal rights by the police authorities. Your Honour, I will now draw your attention to my client's change of plea to not guilty. As previously indicated in my submissions, my client is a vulnerable Indigenous child who has not been awarded his legal rights. Throughout his whole time in police custody, from being questioned by the police to being formally interviewed, my client has displayed obvious gratuitous concurrence in his communications with police due to his cultural background. At no time during the police investigation into the incident had my client been awarded the appropriate consideration of his cultural background. There are numerous instances throughout his questioning and interview that highlight an obvious cultural barrier. Your Honour, throughout his whole time in police custody, my client displayed discomfort, lack of eye contact, and gratuitous concurrence. It is well known that when dealing with persons in authority, all children, and in particular Indigenous children, will answer authoritative questions falsely with the aim to please the authoritative figure. It is my submission that by not being afforded a support person throughout the police questioning, my client had been severely disadvantaged. He had misinterpreted the police's question and provided the police with false admissions of guilt. Furthermore, it is my submission that without this admission of guilt, the prosecution would have no real evidence to make a case. Your Honour, by taking each factor into consideration, I must reiterate to the court that my client is a vulnerable Indigenous child who has not been provided his legal rights or the adequate consideration that should be met by police authorities dealing with persons from diverse cultures. Therefore, I recommend that the court should quash this indictment under Section 590 AA of the Criminal Code. Your Honour, this completes my submission.